Hello everyone and welcome to the webinar. I'm your host, Kate Barrett, and I'll be shortly introducing and handing over to Dr. Feldman. But first, I wanted to thank you and really say a massive thank you for not only joining us today, but for wanting to go through all of this information that we've got with you about a recent case that Dr. Feldman worked on. He's got lots to go through with you, and it's going to be a fantastic session. There will be a Q&A at the end of this webinar, so please do make sure that you ask your questions, pop them in the comments box on the right-hand side of your screen at any point during the webinar, and we'll work our way through them in the Q&A section at the end. Before we answer your questions, Dr. Feldman, as I said, is going to talk you through a recent case history and what medical legal consulting is. For over 12 years, Dr. Feldman has consulted full-time to attorneys on all of their medical issues and questions. He's developed an entirely new kind of consulting approach. He's trained over 400 physicians from all over the country over the past 10 years, and over 800 physicians have been to one of his yearly conferences. All of Dr. Feldman's consulting is pre-litigation and pre-trial and helps attorneys manage the medical aspects of cases, increase case value, and save attorney time. Dr. Feldman helps attorneys to help their clients negotiate and settle cases and get the appropriate medical care the client needs. He does not participate in medical malpractice cases and does no expert witness work. So, without further ado, please welcome Dr. Feldman.
Well, thank you very much, Kate. And as always, thanks for doing such a great job as our moderator. I can now say such a great job over the years, right? We've been doing this for a while. And thanks to, thanks to all of you for joining the webinar. I know we have an interesting case for today. I thought I'd start with a very brief introduction of what medical legal consulting is all about. For those of you who may not have been on one of our past webinars or have not talked with me by phone sometime in the past, I'll give you a brief introduction in a moment. But first, by way of introduction, for years, I practiced psychiatry and psychoanalysis. My area of specialty was mild traumatic brain injury. I owned outpatient head injury rehabilitation clinics around the country using a treatment program of my own design. I think we did a great job helping brain injured patients get back up on their feet. As part of my work, I testified as an expert witness, really more times than I want to remember, on behalf of my patients who were either being cut off of their medical care or offered some pittance of a settlement. I eventually sold those clinics for a handsome profit. I was thinking about what I wanted to do next and thought I could consult to attorneys pre-trial, pre-litigation, regarding any kind of medical question they had in a case. That turned out to be a great thing, and as it turns out, filled an unmet need. My initial plan turned into a new subspecialty of forensic medicine that I've refined over the years. When I started, I looked around the country for other physicians doing this kind of work, and I really couldn't find colleagues who were acting as medical consultants in legal cases. I've now been doing this work full-time for 12 years and training other physicians how to do this kind of consulting over the past 10 years. I answer any kind of medical question that comes up in a case. I don't do, as Kate said, any expert witness work, and I don't work in medical malpractice cases. As I said, all the work is pre-trial, pre-litigation. I consult in personal injury and workers' compensation cases, but I want to emphasize that any physician in any specialty can learn to do this kind of non-clinical consulting. One of the things that makes this kind of consulting viable and makes it go is that in these areas of the law, approximately 9 out of 10 cases settle, and that's where we come in. The case is negotiated, and then a settlement is reached, and the case never goes to trial. So we're helping the attorney settle cases for better value, save time, and helping the attorney get the appropriate medical care for their clients. Let me digress for just a moment. I always work on the side of the little guy going up against the insurance companies, often their own insurance company denying legitimate claims. In PI cases, the quote little guy is the plaintiff, and the insurance company is the insured or the defendant. In workers' comp cases, the little guy is the claimant, and the insurance company is the respondent. It's important to understand. I act as a medical consultant in legal cases. There is actually a huge difference between a medical consultant and a medical expert. In fact, they are two completely different things and perform very different functions. What I now know is that there have been medical experts for years. However, there have not been medical consultants in legal cases until I started doing this work about 12 years ago. I want to reiterate, as a medical consultant, you'll answer any kind of medical question in a case, and any physician in any specialty can learn to do this work. The attorneys understand. I'm not a walking, talking encyclopedia of medicine. They expect to pay me for my research time. If you have some intellectual curiosity, enjoy lifelong learning, and an interest in medicine in general, this work is really interesting, fun, actually. I also want to say the work is really rewarding. I'm helping people who would not have been afforded this kind of medical consultation help to help them get back on their feet after a traumatic accident. Bottom line, we help attorneys settle their cases for more money, save attorney time, and help attorneys get the appropriate medical care for their clients. Okay, let's get into today's case. There are over 15 different services and consultation types that you can provide attorneys. Today, we are discussing independent medical exam observation and writing IME rebuttal reports. So, this is a case of a 30-year-old man who was a bicycle repair technician. After repairing a bike, he took it for a test drive. The client was wearing a bicycle helmet. And during the test ride, the client noticed there was a faulty pedal. And shortly thereafter, he went headfirst over the handlebars and landed on his head on the pavement. In fact, he hit with enough force that the bicycle helmet actually cracked. Now, you can read my IME rebuttal report if you've not done so already. By the way, uh, I hope you noticed there was a link to the report when you registered for the webinar. Hope you've had an opportunity to take a quick look at the report. The report is available at the link on your slide, or you can send me an email to armin@golegaldoc.com, and I'll send you a copy of the report if you don't have one. So the client was diagnosed with mild traumatic brain injury and then subsequent post-concussion syndrome manifested by headaches, cognitive loss, and depression. He also sustained other physical injuries described in my case report that included temporomandibular joint disorder, TMJ, as well as neck and low back pain. Now, during the course of the client's treatment, an independent medical exam was ordered by opposing counsel. The purpose stated for the IME was to evaluate the diagnosis of MTBI and give an opinion regarding causation, diagnosis, symptoms, and treatment. 95% of IMEs are actually ordered by opposing counsel. You should know, in reality, practically speaking, IMEs are often ordered by opposing counsel to either deny the injuries are accident related or to deny medical treatment caused by the accident. Now, a quick digression. I call the injured person a client in my reports and not a patient. In fact, physicians starting with this work often make that mistake and call the injured person a patient in their reports, and you don't want to do that. My client is the attorney and not the client of the attorney. So the client of the attorney is actually not a patient of mine. My client is always the attorney. Okay, moving on. So I was asked by the client's attorney to observe the independent medical exam and, if appropriate, to write an IME rebuttal report. So I discussed the case with the attorney, of course, and then I read the medical records and then interviewed the client by phone to clarify the records and get a current history. And then I was ready to observe the IME. After the attorney read the IME report, the attorney asked me to review the report and then write an IME rebuttal if I felt it was appropriate, which in fact I felt it was. So at that point, I then did the needed medical research and then went on to write my report. So let me say just a few words about IMEs. These reports used to be called second opinions. And then sometime during the 1980s, insurance companies started asking doctors to do these exams, and they changed the name of the activity to independent medical exam. Now, I know there are very good doctors who consistently do very good IMEs. And I'm not usually involved in their IMEs, although some attorneys have me observe every IME for every one of their clients, no matter the IME examiner. Here's what I also know. I know that in every community across the country, there are a group of doctors who make all of their income or a good deal of their income doing IMEs. Now, these doctors are under tremendous secondary gain pressure. The fact is, if they don't consistently come down with opinions that favor the insurance position, the insurance companies will find doctors who do. As I said, approximately 95% of all IMEs, they're ultimately paid for by insurance companies. And you should know that's usually through brokers. So to reiterate, my IME rebuttal is based on, of course, I review the medical records, then I interview the client. I'll do that by phone, but most of the time what happens is that I'll participate in a client prep meeting with the attorney. Then I will observe the history and the physical in the IME, and then review the pertinent medical literature. Now, a few words about IME rebuttals. Let's say if the question is whether the client should have this particular surgical technique or that. Well, I'm not qualified to make that kind of determination. I can tell you that in over 12 years of doing this, I have not felt comfortable writing a rebuttal, maybe less than a dozen times. However, let's say, as an example, that the client tears their rotator cuff at work, goes through conservative treatment, and then needs a rotator cuff repair. And after that, goes back to the surgeon who did the surgery with continuing symptoms after appropriate post surgical treatment. Guy goes back and essentially says, Doc, I have the same symptoms before the surgery. And the surgeon says, well, as we discussed, uh, in some cases, it's necessary for us to do a revision surgery. So that gets ordered. The insurance company says, well, we couldn't possibly pay for a revision surgery without getting an independent medical exam. I observe the IME. The IME report comes back, and the IME doctor says, well, revision surgery, it's not indicated. Well, I'm capable, you're capable, any good doctor is capable of reading about rotator cuff tears, reading about rotator cuff repair surgery, and then going to the medical literature and reading about the current indications for rotator cuff revision surgery, and then writing a report based on the medical records, their interview with the client, their observation of the history and the physical in the IME, and their review of the literature. Now, that's not the case that we're going to discuss today. If you're interested in that case, email me and I'll send you my IME rebuttal for that specific case. Now, as you'll see in my report, I disagree with the IME's doctor's conclusions, assessments, and diagnosis. And let's go over my report. What I'll emphasize to you now are the parts of the report which I specifically refute, and I refute the IME doctor's conclusions. In fact, based on my opinions to a reasonable degree of medical probability, I felt many of the IME doctor's conclusions in this case were particularly egregious. So let's go over the report. So you'll see that I start with an introduction and then what I label the brief history of events, which is essentially the history of the present illness with some additional things often thrown in. I often keep this section short because it's repeated in every medical report that you read. The next section is ongoing medical problems. And in attorney language, it's in this section that I describe the medical damages in the case and provide evidence for the attorney based both on my opinions and evidence from the medical literature. So in this section, I talk in some detail about the sequelae that the client had after his injury, including headaches, cognitive loss, and depression. And by the way, these are all classic symptoms. The literature's chock full of this. These are classic symptoms of mild traumatic brain injury and subsequent post-concussion syndrome. Then in the next section, I felt the next section is the discussion section. And in this section, I felt that it was necessary to address some specific issues. By the way, after the depression section and ongoing medical problems, then I talk about the client's physical injuries, including the traumatic brain injury and also his low back pain and neck pain. Now, one other thing that I felt was really necessary to address in this case, based on the opinions of the IME doctor, was the client's recovery from iatrogenic narcotic medication addiction. So as I stated in the report, if you don't have it in front of you, the client was Mr. B. Mr. B was treated with various narcotic medications for pain, eventually became addicted to oxycodone and OxyContin. He underwent withdrawal treatment at St. Augustine's Hospital in August 2018 and has remained off these narcotics since that time. Mr. B is taking Suboxone, and then I report he's taking Suboxone in a reducing dose to get off the medication. But I felt it was important since that the IME doctor laid so much off on the client taking narcotics, which of course he only took because he was in the accident. But I thought that it was important to state, it should be noted, Mr. B states, he did not abuse illicit or prescribed drugs prior to the accident. He also reports he took the prescribed oxycodone and OxyContin exactly according to prescription directions. Oh, I think I got ahead of myself. I went one too many on the slides. Then in the discussion section, I first talk about the client's traumatic brain injury. So the IME doctor states, quote, it's improbable that he got depressed due to the injury from 2017. And then I go on to say, well, no, after all, that is one of the cardinal problems with mild traumatic brain injury. And I quote the literature on that point. And then I go on to say, then in the next paragraph, the IME doctor states, Mr. B had a fall off a bicycle on April 14, 2017. At that time, he hit his head. In his history, as he presents it to me, he had what appears to be a brief loss of consciousness, which would be diagnosed as a concussion. This was not severe enough to cause post-concussive disorder. And then I state, well, the doctor suggests that because Mr. B had a brief loss of consciousness, his head injury was not severe. This is kind of a ludicrous opinion. And first of all, I said it was my medical opinion that, and I put it in quotes, that the injury, in fact, wasn't not severe. He hit his head, he cracked the helmet, he had significant symptoms that are classic for MTBI. And I go on to describe the literature that backs up those opinions, and then also quote some objective evidence. He actually had some brain imaging that came up with a diagnosis of brain injury. Then on page 5 of the report, I quote the fact that the client has been seeing a psychiatrist and that the psychiatrist's diagnosis is in fact dementia due to head injury, to head trauma with behavioral disturbance and depressive disorder due to head injury. Then I go on to refute this point that the IME doctor points to the issue of whether or not Mr. B lost consciousness. It's well accepted in medical literature that loss of consciousness is not necessary to sustain a traumatic brain injury resulting in post-concussion syndrome. And then I go on to quote literature to that effect. And then later on that page, in page 5, the IME doctor reports through 2017 and 18, when one would expect a head injury to have the most serious sequelae, he was functioning well. It is improbable that post-concussion symptoms would start in 2017 and continue for 2 years thereafter. Well, he was not functioning well. In fact, the client reported he was not functioning well. His fiancee reported he was not functioning well. And the IME doctor goes on to state that he was working properly, which in fact he wasn't. And he didn't base that opinion on anything. It was just pulled it out of thin air. And then I also, at the end of that page, talk about, well, when he was most severely impaired in 2018, before he got treatment, he was on the narcotics, which of course will make a mild traumatic brain injury worse. And then quote literature to back that up. then I felt it was important in this specific case to refute the issue of the substance abuse. In the report, the IME doctor states, quote, Mr. B's depression was maintained by his substance abuse and dependence. He goes on to state, quote, though he blames his life circumstances on the injury, his downhill spiral, including employment and relationship issues, were related to drug use. What he doesn't say, of course, is he's on the drugs because of the accident. But of course, that would be the case. But I go on to state, unfortunately, now that Mr. B has significantly decreased his use of psychoactive drugs, his cognitive impairment continues. It's my further opinion, now that Mr. B is no longer taking opiates other than Suboxone, he should undergo repeat neuropsychological testing. It's my opinion the neuropsychological testing is another objective way to measure Mr. B's cognitive condition. And then I felt it was important in this case, again, because it was quite egregious, to talk about the IME doctor's claim of misrepresentation of history. The IME doctor states, quote, Mr. B's presentation is complicated by misrepresentation. The IME doctor states, quote, he held a job at Denver Tea Company with no evidence that he performed poorly, which of course he did perform poorly. And then at the bottom, I state of the sixth page, in addition, Dr. Van Helsing makes a case that because Mr. B went on vacation trips, he could not be significantly injured. It's my opinion, individuals with depression or cognitive loss can still move about and can be active enough to engage in activities like travel. Mr. B's condition has not made him bedridden. Dr. Van Helsing's conclusion here is somewhat incredulous. And then I go on to give a brief summary. Okay, so that is the case, as well as a brief introduction to medical legal consulting and what this kind of work is all about. And I'd like to now see what questions I could answer for you.
Wonderful. Thank you so much, Dr. Feldman. That was really interesting. And we've had a couple of comments and questions coming in. So we've had a few people who have dropped their email in the chat box, and I've noted those down if you have, who wanted a link to the other case that you were talking about. So I will we'll send those over to everybody who's given our email address, or if you'd like to email Armin at GoLegal in the chat box as well, then that's another way to get a copy of that case. Okay, so we had a question come in from, and please do excuse me if I pronounce anybody's names wrong. I do apologize in advance. We've got a question from Noel, who asks, when you say observe the IME, do you mean analyze it or actually be there for the IME?
Yeah, that's a good question. And the answer is, I actually physically sit in and observe the IME. In fact, I think I may have been the first doctor in the country to do this. Obviously, IMEs have been going on since the 80s. And it was only it was only starting 12 years ago that there were actually physicians, now that I've trained other physicians, who are actually physically sitting in, observing the IME on behalf of the injured person, the plaintiff in a PI case and the claimant in a workers' comp case. Now, the rules about this vary state to state. However, for the most part, they are at least similar. So you would have to check with the rules, or check with an attorney that you know in your state regarding these rules. But having trained physicians coast to coast, there really hasn't been a state where this hasn't been possible for a physician to be there on behalf of the injured person. So in Colorado, by the way, I observe maybe 3 or 4 IMEs a week, and I write 2 or 3 IME rebuttal reports a week. But in Colorado, by rule, The IME examiner, for example, can refuse to have the spouse of the plaintiff or the claimant in the exam room, but they cannot refuse them having a physician present on their behalf. So the rules in Colorado state that uh, the IME examiner can't talk during the IME. They certainly are able to take notes. I take copious notes during an IME observation. And then I wait, and the IME report comes back anywhere from a week or maybe 3 weeks. And the attorney in the case will read the report. 90%, depending on how we view it, from the injured person's viewpoint, from a societal viewpoint, however we view it, 90% of the time I'm disagreeing with the IME doctor. And so the attorney will call me. They're not happy with the IME report, and they'll ask me to write an IME rebuttal report.
Wonderful. Okay, so the next question comes from Lee, who asks, in the case of the rotator cuff injury, it is certainly possible to read about rotator cuff surgery revision criteria. That literature may indicate that under the circumstances in this particular case, revision works, say, 60% of the time. But that is not the same as the knowledge that a well-trained surgeon would know. As an example, that particular surgeon would have what might be called soft information that either leans in favor of surgery versus against surgery. How does that variety of opinion between the literature and an actively working surgeon affect the recommendations you can make?
Right. Well, obviously, I'm not a surgeon, but here's how it works in practical terms. So, all I can do is do my very best job based on the criteria that I mentioned earlier, to give my very best opinion to a reasonable degree of medical probability. And the way that and you have to remember, I'm working in those 9 out of 10 cases that are negotiated and settled. If this case can't be settled and is going to go to trial, then the attorney that I work for will hire an orthopedic surgeon to be a retained expert at trial. But that's not the case I'm working in. I'm working in the 9 out of 10 cases that are negotiated and settled. So I will give my medical opinions based on my review of the medical records, my interview with the client, and my review of the pertinent medical literature to a reasonable degree of medical probability. So what happens is I'll write that report and give by the way, in the case that I just spoke about, based on my report, the client was afforded a revision surgery. But what happens is, so I'll submit my report to the attorney, obviously, that hired me. My report will certainly go to opposing counsel. And of course, this doesn't happen to me now, but early on in my career doing this, opposing counsel would call the attorney that I wrote the report for and say, well, wait a minute, Dr. Feldman isn't an expert in rotator cuff cases. And what my attorney will say, and still says now, is, well, Dr. Feldman works as a medical consultant for me in all of my cases. And I can tell you, if we can't get this point negotiated in a settlement, and you forced me to take this case to trial. When I hire my retained expert, they're going to be using the exact same literature that Dr. Feldman used in coming up with his medical opinion. So let's get the case settled. And that's how it works in practical terms.
So Dr. Bell has asked, is there a TBI textbook that you recommend?
Sorry, I forgot to unmute.
That's okay.
Not so much textbook. I would recommend that you rely on the current literature.
Okay, wonderful. And Shay has asked, well, I'm not actually sure what that question is. Shay, do you want to? Oh, it might be a double one. Hang on, let me see if this patches together. So, interesting case revision, TBI, what I treat, and post-concussive syndrome is way too loosely used and not applicable after a certain period of time. Yeah. So, okay, no, Shay, I think you're going to have to revise that question. I think we might be missing a bit off of that. So we'll come back to that one. That one's not quite fully formed. So Robert has asked, have you ever been called to testify in court or for a deposition on a case in which you served as a medical consultant? If not, what would you do if you were subpoenaed to court?
I've been doing this 12 years. I've done over 2,500 cases, probably closer to 3,000. I have never been deposed. I have testified as an expert once, and that was as a favor to the attorney because some of her treating doctors were no longer practicing. And you're not going to be asked to go to trial because, and this is a legal term, but everybody is going to stipulate. The attorney I work for, even opposing counsel, is going to stipulate that I'm not an expert in everything. So if the case is going to trial, at that point, they'll need medical experts in every area of injury. But for the purpose of negotiating and settling the case, what the attorney needs are well thought out, well reasoned medical opinions, reports, and other services that provide them with, in legal terms, the evidence to back up their medical theories based on the medical fact pattern of the case. And negotiate the case to settlement. And since 9 out of 10 cases settle, there is a demand for these services.
Fabulous. Angelo has asked, can you only be a consultant in a state you are licensed?
Probably not. First of all, let me tell you this. Every one of these medical legal consulting businesses is a local business. By the nature of the business, by the nature of the marketing for the business, by the nature of the kinds of consults you're going to do, you're going to confine your consulting to your local area. There's plenty of business in every local area. I think in a broader sense, you probably, as long as you have a medical license, you could probably consult anywhere. But from a practical standpoint, you're only going to be consulting in your local area.
Okay, thank you. So Shay has asked, what are the background requirements for this type of work? What about compensation?
Well, that's two questions. Let's do compensation second. The requirements for this kind of work are that you are a physician, an MD or DO, that you have practiced some and that you have an interest in doing this kind of work. Right now, there are no other requirements. Now that I mentioned this in the last webinar, now that I've trained over 400 people, there are physicians doing this coast to coast. I'm getting, and I was the one that originated this kind of consulting. I'm getting a lot of requests from the physicians around the country that we now start our own society, that we have our own testing, and that there's a certification in this, and that's one of the things on my list to do. But right now, that isn't required.
And the compensation?
Oh, thank you, Kate. The way that I've been advising other physicians for years is do an informal survey of your colleagues. Determine what you think is the average fee per hour by the way, I charge by the hour, same hourly fee for everything that I do. Determine what you think is the average fee per hour for doing medical expert work in your community. Now, obviously, there's a range on that, depending on specialty, but it's really not that hard to figure the average. Once you've determined that average, it's my advice to you that as a medical consultant, as opposed to medical expert, you come in somewhere below the prevailing rates for medical experts.
Okay, wonderful.
Actually, let me
S-
just say one other
sure.
thing about that. We cannot, as physicians and other fields too, we cannot specifically talk about fees. To do that, it's actually against the law. It's a violation of free trade practices in the United States. So we can't talk specifics about fees. That's fee fixing. And in fact, if I did that, or anyone does that, there's actually a fine for that of $71,000 per violation. So we're not going to talk any specifics today.
Okay, that's good to know. So Stephen has asked, do you get called upon from counsel from plaintiffs and defendants?
I actually don't. First of all, I have my own moral and ethical obligations, but objections to working on the insurance side. I won't do it. I don't want to do it. But what will happen in practical terms is you could say, well, I work both sides of the fence. But what will happen is that you'll get self-selected by the attorneys for one side or the other. Now, let me say something about that. Sometimes doctors ask me about being a quote hired gun. And one of the great things about being on this side of the fence, that is, working with plaintiff and claimant attorneys, is that these attorneys want and value and hire you for your straight up medical opinions. Uh, so I am never, ever faced with these kinds of secondary gain issues that may affect some doctors, including doctors, some doctors that do IMEs. So hopefully that would answer that question.
Lovely. So Lee has asked, what is the difference between the 400 who are trained and the 800 who have attended a course?
Yeah, that's a good question. Let me answer that this way. The biggest reason why physicians fail at doing medical legal consulting, maybe the only reason, is that really two things. First, they don't carve out the minimum time necessary in order to make this go, which is about 8 hours a week during the regular work week, and or they don't take it as seriously as anything else that they do in their professional lives. Now, if you don't do those two things and you just follow the system, follow the recipe, there are physicians, lots of them, successful physicians doing this coast to coast.
Oh, are you still there, Dr. Feldman?
I'm sorry. Oh, did you miss that answer?
I think so. You said so. There's people doing it from coast to coast, and you need to follow the
Or just
the
follow the
information
system.
that
Oh,
you've
did I
sent.
cut out? I'm so sorry.
Yes.
Just follow the system, follow the recipe. If you just follow the recipe, this kind of this kind of plan has worked for doing medical legal consulting coast to coast. So the biggest reason physicians fail, they don't carve out the time necessary to do this. They don't take it as seriously as anything else in their professional lives. Don't do that and follow the system and you will be successful. And there are plenty, there a couple hundred people that could attest to that.
So what's the difference between the 400 who are trained? So I think this was from my introduction to you, and the 800 who've attended the actual course. Is that
Oh,
the
oh,
difference
oh.
between the attendees to the yearly conference and those who've then gone on to receive additional training and
Oh, I
support
see,
from
I
you?
see. Yes, yes, yes. There are two ways to get I'd misunderstood. There are two ways to get the training. One is to attend my annual conference. Every year I do a 2-day conference. It's really a crash course in how to do this. And one of the very first things, and by the way, that's coming up on May 2nd and 3rd in Denver. And if you want I mean, we didn't, this webinar is educational. It really wasn't to promote the conference. But if you want information about the upcoming conference, email me and I'll get information to you. And one of the very first things that I say at the conference is, when you leave this conference, you will have all of the tools and all of the instruction necessary to go home and successfully do that. And plenty of physicians do that. Now, the other way to get trained, you can still come to the conference, but the other way to get trained is I do have a 1-year remote training program, my medical legal consulting coaching program, and that is a 1-year collaboration. It is obviously longer, more intensive, more hands-on, and there are additional tools and things I can provide you that are actually impractical to provide at a conference. So if you want to get trained to do this, you can do it either way. It's up to you. You can come to the conference and get trained, or you can get trained and start anytime with the coaching program. And if you're interested in either, email me and I'll send you whatever information you need.
Wonderful. So I've put your email address in the chat box again, Dr. Feldman. So if anyone would like more information, you have the email address there. I've got a list of you who wanted the link to the other case that Dr. Feldman mentioned. So we will be dropping you an email about that as well. And if you do want to go directly and find out more about the conference that we have coming up in May this year, so you're running out of time to secure your spot if you do want to join us, the big red button on the right-hand side of your screen, the sign up now, will take you to a page with more information and the sign up forms to go through and purchase your ticket as well. So there's a couple of options for you there. But if you want to find out more about either, please do feel free to drop Dr. Feldman an email that is in the chat box as well.
Oh, okay. I didn't realize that we had that up there about the conference. But yeah, if you want information about the conference, just click on the button, sign up now.
Wonderful. So Noel has asked, I am currently working doing psych IMEs. I get referrals, 80% insurance or carriers, and 20% patient attorneys. If I do this, which is more for the claimants? Will I be shooting myself in the foot with the insurance companies? So if I do this, which is more for the claimants, will I be shooting myself in the foot with the insurance companies?
Well, as I said earlier, you can certainly advertise yourself as working on both sides. I think the plaintiff and claimant attorneys wouldn't have any problem with your doing that. The insurance companies might.
Okay, no problems at all. So Jamie has asked, would you treat the same patients that you will do in an IME?
Well, first of all, I don't do IMEs. I don't treat patients either. I've been doing this full time for 12 years. There's probably a conflict of interest. If you're doing a medical legal consult, probably shouldn't do it on your own patients.
Okay.
Now that's
Jamie's
different.
asked,
in legal cases, the plaintiff and claimant attorneys certainly rely on what they call treating doctors. Now, this nomenclature isn't rocket science, but the physicians that treat the injured individuals who are working with attorneys, the attorneys call these doctors treating doctors. And if you're a treating doctor, you may be asked to by an attorney to work as an expert on the case, but I probably wouldn't do medical legal consults on your own patients.
Wonderful. So Jamie's asked another question. I'm not sure if we need some clarification here, so let me read it out to you in case you're happy to answer it. So Jamie has asked, I'm in New York or New Jersey. I would love to have more referrals than I already have. Any thoughts on referrals? Do we need some more clarification there?
I'm not sure what the question is.
Yeah. Okay. So Jamie, if you could just clarify your question, that would be fantastic. Okay, so that's sort of the questions we've got for right now. We've still got a few minutes left of the webinar, so if anyone does have any other questions, please do pop them in the chat box. We've got a couple of questions that were sent in before the webinar as well, so let's go through some of those as well. Okay, so Stephen has asked, can you talk about how to get attorneys to use you instead of other medical persons?
Yeah. So one of the things that I teach about both at the conference and the coaching program is you really need to have a structured marketing plan to do this. But what I can tell you is that um, your marketing really shouldn't have anything to do with advertising. In fact, it really doesn't have anything to do with spending money. What it has to do with is old-fashioned elbow grease. The best way to get your clients is to meet with attorneys face to face and explain to them how you educate them on what you can provide them in their legal cases.
Okay, wonderful. So Jamie has said that they're a treating doctor, orthopedic surgery, pain management, and have MDs employed. So I think they're asking how they get more referrals for that business. I'm not sure that that question, Jamie, is directly related to the medical legal consulting that we're discussing here. I think that's more asking about how to get referrals for your orthopedic surgery and pain management. Correct me if I'm wrong, but yeah, we're just talking about medical legal consulting and setting up this business and how we go about driving to that business. So the question that Dr. Feldman has just answered of how you get people to get attorneys to talk to you and building that marketing plan, hopefully will help from that side of things. So is this a full-time job, or can people work part-time doing this type of consulting?
Yeah, good question. There are physicians doing this full time. There are others do it instead of retiring. The largest group, though, are physicians that do it as part of an existing practice. Let me go back, Kate, quickly to Jamie's question, because what Jamie's question, she's asking this, but not in a direct way, is she's saying, I can act as a medical expert in my particular field, and I want more business for that. And but it brings up the point that I'm not talking about acting as a medical expert. I'm talking about acting as a medical consultant in legal cases. And as I said earlier, being an expert and being a consultant, they're two completely different things, completely different functions. And medical experts really primarily work in cases that are going to trial. Medical consultants work on those 9 or 10 cases that never go to trial, that get settled. Hopefully that answers that question.
Wonderful. So hopefully, Jamie, that was useful and helpful there with your question. Excellent. So let's have a look what we've got coming. So Noel has asked, when you go to observe the IMEs, do the attorneys pay for the time and that trip?
Yeah, so as I said, I charge 1 hourly fee for everything that I do. I always give the attorney an itemized bill at the end of whatever it is that I'm doing. And so, yeah, whether you charge for travel time, that's kind of a marketing decision. But I certainly charge for my time spent interviewing the client, observing the IME. By the way, some of these IMEs can last up to 4 hours. My time for doing research and anything related to providing the attorney with their request.
And a follow-up question from that from Noel as well. Is there an average time per case? And they're saying that I'm sure it depends on how complicated it is, but do you have an average time per case?
Yeah, that's a good question. It's very different than doing medical expert work. So the average case takes somewhere maybe between 5 and 12 hours.
Okay, wonderful. Stephanie has asked, do you need to carry malpractice insurance?
Yes, Stephanie, that's another good question. There are two answers to the question. I'll give you the bottom line answer first. If you are concerned about that, I would suggest that you hire an attorney in your state, have the attorney answer that question for you and give you a written answer. Here's the other answer. I'm not an attorney, so I want to preface what I'm saying, but I don't think that you need medical malpractice insurance to do this. I don't carry it. Um, I do think you need errors and omissions insurance that any kind of consultant to the legal system would need, whether you're a structural engineer, a police officer, or a physician, or anyone else, an accident reconstructionist, whatever. You should have errors and omissions insurance. That insurance, depending on the state, is going to cost maybe 500 to 1,500 a year. But I am hired essentially to give medical opinions. And all of my clients are attorneys. They certainly know how to sue people. Never say never, but I've never come close to anyone threatening to sue me. But so as long as you render your medical opinions, provide your reports, and in good faith, you do the research that's necessary, you interview the client, you do everything as best you can to a reasonable degree of medical probability. If someone hires you for an opinion and you give them an opinion, even if they don't like it, which really doesn't happen, but even if they didn't like it, it's very hard to sue someone if that's what you hired them to do. So that's the answer to that.
Okay, lovely. Stephen has asked, do you have cases where the attorney didn't like your opinion or they didn't agree with your opinion? And how does that affect compensation?
So I don't know if I've ever had a case where they didn't like my opinion. Um, Sometimes the attorney, let's say I tell the attorney, look, I think your case is weak because I really can't find any objective evidence in the medical literature to support your medical theory. Um, they may go ahead and still try to pursue that, but uh, I really can't think of any time where they haven't liked my opinion. So, I mean, if I tell the attorney, look, I think you don't have a case because the person's malingering, which doesn't happen very often, or they're driven primarily by secondary gain, which doesn't happen very often, or there's a pre-existing condition that's going to make that very difficult to prove up legally. Um, th- they're happy to hear that. I mean, they need to hear that. They want to hear that.
Okay, good to know. Lee has asked, have you ever stopped a case in the middle due to objecting to that case for some reason?
I don't think that's ever happened, but I will tell you this. Um, there's a high demand for this kind of work. And I have found the attorneys that I work with to be extremely professional. Nothing like the jokes about attorneys. Very concerned about their clients, always wanting to do a good job. Uh, Now, once in a blue moon, if I'm, by the way, never ever take a case without meeting face to face with the attorney before you take a case. But once in a blue moon, if I have one of those meetings and I something doesn't strike me as correct, or my intuition tells me don't work with this person, then I won't work with them. I mean, there's so much work to be had. Use your good judgment and intuition, and in the once in a blue moon, if you find somebody you don't want to work with, don't work with
Okay. Dr. Bell has asked, do you utilize translators that are friends and or family, or do you use a phone translating service?
If the client is not English speaking, I think this is probably true in every state. The client must be afforded, and they're not called translators, by the way, they're called interpreters because they don't actually translate, they interpret. But the client will be afforded an interpreter. So if I might need an interpreter to interview the client, the interpreter might be there at an IME meeting. But so that's how that works.
Stephen has asked, how early in cases do most attorneys contact you? Do they wait until insurance denies, or do they preemptively get your opinion?
Yeah, that's a good question. And one of the things that you're going to educate attorneys about when you meet with them face to face is how important it is for the attorneys to bring you into the case early on. So before there were medical consultants, by the way, um, attorneys tended to bring in physicians, primarily medical experts, into the case pre-trial, pre-litigation, when they felt they had some perceived problem or crisis in the case. So, but the fact is that the attorneys, in fact, I mean, it's not just something to say, the attorneys, in fact, when they use a medical consultant, whether it's me or somebody else across the country, they, of course, not in every case, but in most cases, in almost all cases, they're going to increase their settlement value. So what happens is you do a couple of cases for an attorney, they realize that compared to the fee they're paying you, they're making a pretty good rate of return on investment in terms of the settlement amount based on using your services, and they kind of educate themselves, and then we'll start bringing you on early in the case.
Okay, so what are the business startups to actually get into starting your own medical legal consulting business? What are the startup costs, and what kind of learning curve is there to get up to speed?
That's two questions. The startup costs are minimal. You need some marketing materials, some domain names, a website, and so forth. Everybody has a computer with internet access. So the compared to other businesses, the startup costs are remarkably low. Um, the In terms of getting up to speed, the way that I have advised physicians over the years is you will learn the medicine you need to know as you need to know it. Now, obviously, when you start out, I don't think it's fair to charge attorneys for your learning curve, but it's certainly fair to charge them for your research time. And so, in fact, it's one of the real pleasures of this work. Now, I'm not prepared to do any orthopedic or neurosurgery, but at this stage of the game, I certainly would put my knowledge base of, for example, spine injuries up against anybody. But that was on the job learning. And so you learn. And by the way, you're going to be confronted with all kinds of things that you may have remembered from medical school, but you've got to do the research and uh, do your very best job to get the attorney the information that they need.
Wonderful. Okay, so we are just past the top of the hour. Those were some fantastic questions that came in. Thank you to everybody who put questions in the chat box and everybody who has joined us today for this webinar. We hope you found it really useful and got a lot of information out of it. So there were quite a few of you who put your email addresses in the chat box. For those of you whose email address I've gathered, we will be sending you out the information about the other case that Dr. Feldman was talking about a little bit earlier on. If you don't get that email for any reason, please do email Dr. Feldman directly. That email address is it in the chat box as well. I can see a few of you putting your email address in now, so I'll gather those as well. If you would like to find out more about the upcoming conference or about working with Dr. Feldman directly in his coaching program, again, you can drop him an email, or if you want to find out about the conference, the big red button on the right-hand side of your screen is where you can go to find out more and to book your tickets. And I would recommend doing that very, very quickly, because the tickets and the VIP tickets in particular are selling out really fast. But today has been helping you with information, going through that case study. So as I said, we do hope that you found it useful, and thank you very much for your time. Thank you, everyone. Bye-bye.